Call in progress.
All right, this is LAWS 13017 civil procedure. This week we're looking at disclosure and a couple of tutorial problems related to that. So welcome everybody. Just stop sharing that splash screen. There we go. Now we won't talk about the assignment at the moment because there's still a few people that have got medical extensions. So we can have a chat about that next week, because all of those will be out of the way by then. But I can say the marking's progressing and the sky hasn't fallen in, everything's fine. So we'll have a good look at that next week. This topic of disclosure is a really important one. It's an area where the costs of litigation really skyrocket. You recall I keep mentioning those areas when you first start the proceedings. So you get your initial advice from solicitors. When you're doing the pleadings is another area, disclosure is another area, and ultimately preparation for trial. So there's really four main areas where if you drew a graph of cost on one axis and time over the other, you'd signal those points as being the expensive areas. The reason why disclosure is so expensive is if you have a case that involves any collection of documents, you've got to spend the money on the solicitor reading through those documents and analysing them. And in the study guide, I gave you a flow chart which sets out the logic when you look at any particular document. But it's quite clear that disclosure is governed by the pleadings, because the pleadings are the things that define the scope of the cause of action. So the broader those pleadings, the broader disclosure becomes and the more expensive it is. The narrower the pleadings in terms of reducing cost of disclosure, the better. All right, so let's have a look at this first problem. Now, did you actually have a chance to play the videos and do the exercise as an interactive exercise? Did anybody try that? There's Mac versions and Windows versions that enable you to actually do problem 18 as an interactive exercise. I sometimes wonder whether people actually use that, but I created all that a few years back to enable it to be more interactive. But essentially what we've got is an agreement concerning it's a tender agreement concerning a blast furnace at this aluminium refinery owned by Harry. And Harry's entered into this agreement with Patricia. The trouble is that the project's 2 months behind schedule. Harry's arguing that Patricia hasn't complied with the terms of the agreement. There's been cost overruns around problems with the foundations. Harry's then commenced proceedings in the Supreme Court seeking damages and breach of contract. Patricia's put in a defence which is saying that the cost overruns have been due to encountering unexpected water table, and that hadn't been detected in the original soil test. Because of that, the water had to be drained and the area capped off so that they could continue on with the construction. That's caused the extra cost and delay. And that Patricia is in the defence is basically saying that there's a clause in the contract and the tender documents dealing with unforeseen events, and this is an unforeseen event. And that because of that, she's got a defence and is not liable for this extra cost. So that's the basic scenario. So that outlines the scope of basically the scope of the pleadings. And then Harry's instructed you to take over the proceedings on his behalf and has provided you with all of these things. Now it says the following documents. Now that's really the issue. Are these things documents? All right, so why is that important, this question of whether something's a document or not? Shouldn't you have to disclose everything? Does matter if it's a document? Is there a duty to disclose things that aren't documents? What do you think? What about Tanya? I haven't asked Tanya. What about you, Tanya? What do you think? Can you disclose something that's not a document?
I think you can, but it's not required to be disclosed if it's not a document.
Yeah,
I can't quite recall the evidence.
Yeah, so there's Rule 211 of the UCPR talks about the duty of disclosure. And the way it's expressed is that there's a duty to disclose to each other party. So that means it's a duty on both sides, both for the plaintiff and the defendant, to disclose, in effect, to the other side, each document. So it doesn't say anything else. It says each document. Then there's some qualifications to that, in the sense that the document has to be in the possession, so they have to physically have it in their possession, or under their control. So what that means is you can direct somebody to give it to you. So for example, it might be locked up in a bank vault. You can direct the bank to unlock their vault and you can get it out. So that would be under your control, or it might be held by a third party, but you can direct the third party to give it to you. So in the possession or under control of the first party, and because that's one requirement, it's got to be directly relevant to an allegation in issue in the pleadings. So this is where the pleadings become important. And it's got to be directly relevant to an allegation in issue in the pleadings. So if it's not connected with the pleadings, you don't have to disclose it.
Sorry,
Yep.
Stephen, may I just ask a question there? If there are, directly relevant to an allegation and issue in the pleadings, is the concept of directly relevant to the pleadings self-assessed, or is there some other way of the person that's disclosing being checked or supervised?
Okay, so in relation, let's go back a step. Where this historically came from is that it used to be the case that you had to disclose every document, whether it was an original, whether it was a copy. It was really broad. And that created problems with delay and expense because, say, for example, in banking cases, often the documents go all around the world. So you would have to try and track where everything went. Terribly expensive. So they started narrowing down the scope of disclosure. And there used to be a case called Peruvian guano. And basically that was narrowing down to things that are directly relevant. Now that's an assessment made by each of the parties. Okay. Now, there's a duty to the court to disclose. That's a duty on you, the solicitor, when you're doing your job. Yeah. Now, if your client hides things from you, shreds things from you, doesn't give them to you, you're not necessarily aware of that document. Now, one of the things that you would do when you're doing disclosure is you would prepare a database effectively, and it would list all of the documents. It would give them a code number. Usually you would have another column which would indicate which allegation in the pleadings it's relevant to. And then you would have another column which would cross-reference anything that's any other document which is referred to in the document you're looking at. So if you're picking up a letter, for example, it might have CC, a copy has gone to somewhere else. You would make a note in that third column that a copy has gone somewhere else and that you would be aware of it. If you have got, say, the file copy of a letter, so you've got the copy, you know the original has been sent to someone else. So you would list that in the other column. So that when you actually get the list of documents from the other side, you would go down your column and identify all of the documents you expect the other side will produce. And if they don't produce them, then you will raise that issue and you would raise you know, and make an application for further disclosure of documents. And of course, that then casts a negative view on the other side. It presents them as hiding things. But the other advantage of doing this exercise is it tells you if there's things that your client is hiding. Now, it's not going to pick up everything, because if they're very good at this, they can still hide things. And sometimes clients will do that, intentionally or unintentionally. They intentionally might do it because they see something as particularly damaging to their case. And then they might think, well, if I destroy this, then no one's going to know about it. But sometimes you can actually identify that there's a missing document. And that doesn't look very good where you've got that sort of situation. So that's the sort of process you'd adopt if you've got a lot of documents. So the other thing you need to do is you prepare your database and the links, and that's searchable. And then you would have a series of files behind you, which would have all of the documents in the coded order. So that, for example, if you're required to find something quickly, you can look up and search through your database, find the code, find the document really quickly. So there's ways of sort of there's a whole lot of management techniques for dealing with disclosure. And all of that can be done electronically. You might, for example, instead of having the hard copy, you may have scanned them all. So everything is retained electronically, and disclosure may be done entirely electronically.
So, Stephen, what you're saying is you link that document to your principal list is?
Yeah, that's right. So it's all about being able to put your hands on the documents you need quickly and being able to search. So that, for example, if your barrister comes along and says, oh, well, you know, what have you got on this particular, what documents you've got in relation to this particular item in the pleadings, you can find that, like, you know, in seconds, because you've got a database set up to manage that sort of process. But you can imagine that all involves cost and time. That's why disclosure becomes expensive. But it has to be directly relevant to the allegation issues, the main thing, and it's self-assessed by the solicitors acting on behalf of each party.
I can see how problematic that would become for a
If
self-representative
you're
person.
a self-represented person who's got a case with a lot of documents,
Yeah.
you know, you've got to be a person that's got one of those. You can manage the databases and things to be able to deal with that.
But there isn't that independent check though that you've spoken of.
No.
Yeah. Okay.
So Robert said it would be an objective standard. I suppose it is. Now, if there are no pleadings, okay, so there's no pleading. Well, in the Supreme Court, you're going to have pleadings, but if there were no pleadings directly relevant to the matter in issue in the proceeding, that's not that different really from an allegation in issue, a matter in issue. I suppose matter in issue is a bit broader, but we're going to have pleadings in the Supreme Court cases anyway. All right, so that's the duty. Now, there's a few terms in there, like document. The interesting thing about document is that Rule 211 has a note underneath it which refers you to the Acts Interpretation Act. And that Act in Section 36 has a definition of document. But there's also the Evidence Act, which has a definition of document. And what's interesting is that they're not exactly the same, those two definitions. Now, logically, don't you think that's pretty daft? They have two acts that have the same definition, that have definitions of the word document. But anyway, that's how it's been and how it is. So I think either of them will apply to the situation. If you have to prove something, you certainly use the Evidence Act. The Acts Interpretation Act is used to help you interpret statutes, including, you know, rules, which is what we've got here. So when you look at the Acts Interpretation Act, Section 36, it says a document is any paper or other material on which there is writing. Okay. Now, it doesn't say anything about any particular language, whether it's English or anything else. It's just got writing on it. And any paper or other material on which there are marks, figures, symbols, or perforations having a meaning for a person qualified to interpret them. Okay. And any disc, tape, or other article, or any material from which sounds, images, writings, or messages are capable of being produced or reproduced with or without the aid of another article or device. So you can imagine all sorts of things here, can't you? Anything ranging from one of those really ancient floppy disks for a computer to cassette tapes, to videotape, discs, laser discs, hard drives, all sorts of things where sound, images, writings, or messages are capable of being produced. So it's pretty broad. Okay. All right, and then it says the duty of disclosure continues until the proceeding is decided. So it's a continuing duty. And an allegation remains in issue until it is admitted, withdrawn, struck out, or otherwise disposed of. So if something's admitted, you then don't have to disclose anything in relation to that, or if it's withdrawn or it's struck out or disposed of in some way. All of those things are limiting the scope of what's an allegation in issue and thereby limiting the scope of disclosure. All right. Now, in UCPR Rule 212, so you now know what the duty of disclosure is and how it relates to documents. Rule 212 then tells you about when the duty of disclosure doesn't apply. So that the main grounds are where there's privilege, a valid claim to privilege, where the document relates only to credit of a witness, essentially. An additional copy of a document already disclosed. This is your Peruvian, old Peruvian guano case. If it is reasonable to suppose the additional copy contains no change, obliteration, or other mark or feature likely to affect the outcome of the proceeding. So if you have an original, you disclose that if it's a document that's relevant. But if you've also got a copy, you've then got to look at the copy and then decide, is there something on this copy which is different from the original and which would likely affect the outcome of the proceeding. So somebody may have scribbled a handwritten note on it, for example. And if that's the case, and if it's relevant to the outcome or affecting the potential outcome of the proceedings, you have to disclose the copy as well. But it's still going to entail all the costs of considering all of the originals and copies of things. And this year, when I used to do litigation many years ago, for my clients were all big banks, they would have many, many copies of original documents and they would send them all over the planet. And you had to track down every one of them. And then you had to see if there was anything different written on any of those copies. So it's quite a laborious sort of process. And then it continues on to say a document consisting of a statement or report of an expert is not privileged from disclosure. Statement or report of an expert is not privileged from disclosure. Okay, so the logic here is that you want to exchange expert reports. And the reason for that is that it's trying to encourage the parties to settle. If you know the content of the other party's expert reports, then you get a better assessment of the strength of their case. And you may well decide that you don't need to expend money on having your own expert report if the work's already been done. Or you might decide that it's better to try and settle the proceeding. So that's why this notion of an expert report is not privileged from disclosure. Okay, we'll keep going. And then 213, privilege claim. This rule applies if a party claims privilege and another party challenges the claim. So you don't have to accept if somebody claims privilege. You don't have to accept that. You can challenge it, but it does mean that you actually have to have an argument over that. So if that's the case, then the party making the claim that's been challenged has to, within 7 days, file and serve on the other party an affidavit stating the claim. In other words, setting out why they're claiming privilege. And it has to be an affidavit by an individual who knows the facts giving rise to the claim. So that's there to ensure that the person who's preparing the affidavit is actually knowledgeable about the facts related to that claim. so that you don't have, say, an inexperienced article clerk responding to that. You want the person who actually knows the facts, and it may well be the client rather than the solicitor. So that's more about reducing the hearsay element to make it more in the knowledge of the person giving the affidavit rather than being informed by someone else. So that's what that's about. Okay. Then in the Evidence Act 1977, you've got Section 3 definitions. There's some overlap. It starts to talk about document in writing, book, map, plan, graph or drawing, photograph, okay, label, marking, disc tape soundtrack, that's a little bit like the earlier one, in which sounds and other data, not being visual images, that's interesting, are embodied so as to be capable with or without the aid of some other equipment of being reproduced. Then it says a negative, a film, tape or other device that produces visual images. Okay. All right, so we've gone through the duty. We know that it's continuing. It's on both sides, has to be a document. There are ways of beating the requirement of disclosing things. But if you claim privilege, you may well have that challenged and you'll have to prove why it's privileged. So all of that can then be assembled into basically a diagram that looks like that. So this is the diagram I'd sort of encourage you to follow when you're considering any of these sorts of issues. So you can see the logic. Is it a document, or what's a document? Got to look at those acts. If it isn't a document, then you don't have to disclose it. If it is it directly relevant to an allegation in dispute, which is Rule 211? If it is, then you've got to ask, is it in your possession or is it in the possession or control of your client? Again, 211. If it's not, you don't have to disclose it. If it is, then you start to look at the things that are the factors which set out reasons that you don't have to disclose, like is it privileged? And then you've got grounds of privilege, legal, professional privilege, crown privilege, self-incrimination without prejudice, all of those sorts of things. If it is privileged, you don't have to disclose it. If it isn't, then you ask yourself, does it grow to the credit? And usually that's related to a possible witness. No. So the credit, all of that stuff about credit comes out of the trial. You put the witness in the witness box and you interrogate them, and that's how you sort of attack their credit. It's not done through these documents. Is it a document that's a non-materially altered copy of a document already disclosed? So this is the preview quano idea, is it a copy that doesn't have anything materially different? If that's the case, you don't have to disclose it. If it does have something materially different, you do have to disclose it. Then there are other possible objections you can make to disclosure about, and this is also relevant to interrogatories, which are a series of questions you can ask the other side. So time, cost, inconvenience, importance of the issue, probable effect on the outcome of the action. You can argue things like that. And also, does the document allegate us to damages? And if it is only related to that, then you don't have to disclose it. Again, that's a matter you can prove at the trial. So that's basically the scenario. So we now know what we've got to do. So if we think about our little problem with the blast furnace, it sort of looked like that when you actually run the scenario. So I've actually given you the script here that I wrote to actually do the scenario. So it starts off by this partner behind the desk there telling a junior lawyer who's asking a series of questions. So it sets out the facts, and then, the first sort of question that's asked, where do we find the definition of a document? Okay, so there's the choices here. Acts interpretation, act evidence. It's really both, isn't it? So you'd select both. So that's what happens here. So the little character says both. And then if you make the wrong choice, it'll actually tell you that you've made a wrong choice, and you need to think about both those things. All right, then it keeps going. Now, the first thing here, copy of an expert hydrology report commissioned and provided by Patricia. So is it directly relevant to the cause of action? So it is a document, there's no doubt about that. Is it directly relevant to the cause of action? What do you think? What's the cause of action all about? It's all about this water table, and it's all about the whether that is unexpected or not. So if you've got a report concerning that water table, then it is directly relevant. So is it in your client's possession or control? Well, it is, because they've given it to you. So that's answered. All right, then the next sort of thing, it's a copy. Okay, so where it's a copy, you've got to ask yourself, where's the original? Now, if you think about it, you're acting for Harry, right? And Patricia is on the other side. Probably she has the original, because she may well have commissioned it. So you would be expecting her to have produced that document. Okay. So given that you've got a duty to disclose, it's a question whether she's already disclosed it. If she's gone and disclosed it, you don't need to disclose it, because there's already a copy being, or the original's already been disclosed. But if you haven't seen her disclose, you don't know the answer to that, so you would disclose the copy. So there's a little bit of a timing issue there. All right, keep going. So this is an expert report prepared for the purpose other than the hearing. It should be dealt with under the normal disclosure process rather than the process for expert reports. So expert reports that are commissioned for the purposes of litigation certainly have to be disclosed, because there's a lot of rules in the UCPR requiring that. This document, is it privileged in any way? It hasn't got legal professional privilege. It wasn't produced in, for the purpose of or anticipation of litigation. It hasn't got Crown privilege. It's not sort of like prepared by a head of state or it's a secret cabinet document or anything like that. It's nothing like that. Privilege against self-incrimination. Is anybody going to be subject to a crime or have their liberty at stake or a civil penalty? So civil penalty imposed by the state? No. Is it without prejudice? No. So it's got none of those privilege elements. Does it impact on the credit of any witness? Not really. Is it a copy of a document which has already been disclosed? Well, as far as we're aware of at the moment, we would expect the other side to disclose it, but we're not sure about that yet. So, it may well be something that you'd want to disclose. And there's also that other provision, if I go back up here a little bit, here, a document consisting of a statement or report of an expert is not privileged from disclosure. So you can't rely on privilege anyway for this particular expert report. So where do we end up then, do you think, having considered all those things with this particular report?
It has to be disclosed.
So I think that's something that's got to be disclosed. All right. What about the water sample? Is a water sample a document? You'd have to look at the Acts Interpretation Act, and you'd have to look at the Acts Interpretation Act, the Evidence Act. Is water a document?
No.
It isn't, is it? There's nothing written on it. So if it's in a bottle, for example, with something written on it, maybe, but we're just told water. So the answer, no, it's not a document. So you don't have to disclose it.
Stephen, would the analysis of a sample be disclosable? Because it would
now, if it's an analysis, presumably the analysis produces a report. and that would be an expert report. So that would be something, if it's not prepared for the purposes of litigation, so if there's no privilege attached to it, and remember, even the rule says that you can't claim privilege for expert reports, then that would be something you disclose. It's a question then is how relevant it is. So is it relevant to anything in issue? Now, we don't have the outline of all the pleadings, right? It just says that, you know, there was this water table. So I suppose it depends on the contents of that report, that analysis. If it says that this is a water table, this is from an aquifer or water table sitting under this particular thing, then if there was an argument over whether or not the water table existed, then it would be relevant. But if it's admitted, for example, that there is a water table and that additional costs will occur because of that, if it's admitted, it's no longer an issue, so you wouldn't need to disclose it. Just to get the logic of this, depends a lot on what the pleadings actually says, but generally it's start off with the water as not being a document. The analysis report on it, if we had that, then you'd have to look a bit deeper into the pleadings. Okay, what about a model? The model of the blast furnace. Is that a document?
No.
It depends. It depends, doesn't it?
It's got something written on it.
If it's got something written on it, it could be. So you need to get some more information about that. But just physically, the model itself, if there's nothing written on it, then you'd have to question whether it's a document. But if it does have things written on it, then it would be a document. Is it directly relevant to the claim? Well, I've said yes, but you know, it's a bit arguable depending on what's in issue. The issue here is not so much the design of the actual blast furnace. The issue is what was underneath it when they tried to build it. So, you know, it's a bit questionable that. It's a privilege, no.
If it depicted the
water table underneath it, yeah, well,
stuff perhaps that drilled into the water table.
Well, that's right. If it's like a 3D model that goes and has a section showing underneath that it's got a big aquifer underneath it, it may well be relevant, but we don't know. So again, this is where you have to dig a bit deeper. Okay, what about the soil test? I think that's going to be relevant, isn't it? So the soil test, you know, the argument was the soil test didn't reveal this aquifer, so it wasn't foreseen. So I think the soil test is something that's relevant to the claim. All right, so I think that's probably something you would put in. Then you've got a film, a video of the blast furnace site. Wow. It is a document because it can have film, but it's a question of its relevance. It depends what's on the film. So if the film depicts something that is actually relevant to something in the pleadings that's in issue, then you would disclose it. If it doesn't, then you wouldn't. So you'd have to view the film. Okay, what about this one about emails between the solicitors' firms about proposed settlement of the dispute? An email is a document. Is it directly relevant to the matters in dispute? Well, it is. It's exactly on the matters in dispute. It's all about trying to resolve them. But what's the problem, or what would prevent this being disclosed? It's privileged.
Without prejudice for the purpose of settlement.
That's right. They're without prejudice communication, so you can't disclose those.
Stephen, just on that, for the emails to attract that privilege, does each one literally have to say without prejudice, or can that it can be assumed or implied?
It can be implied, absolutely. As soon as it involves anything to do with settlement. See, there's a public policy element here. The public policy says that we try and encourage people to settle disputes. And the way we do that is to enable them to enter into communications with one another and to talk freely about the matter without any of those communications having any risk of being incorporated into evidence and being used against either of them at the trial. That's the logic behind it. If you didn't have that, no one would talk to anybody. You'd have far more trials. The whole process of negotiations, mediations, and any other form of alternative dispute resolution would vanish. So you've got to have this public policy privilege, in effect, in relation to without prejudice communications, and also in relation to things like mediations and negotiations. Because if we can negotiate a solution way earlier than a trial, that is better for everyone. It's less, except the lawyer, I suppose, because it's, you know, they don't earn the income from billing the parties, but it's better to resolve the dispute earlier. All right, last document, original expert report commissioned by Harry. So what about that one? So it's dealing and refuting Patricia's assertions with respect to costs, overruns and delays. So I've said there's nothing to suggest that this document was created for the purpose of legal advice in relation to actual anticipated litigation so as to attract legal professional privilege. So what do you think about this one? Any ideas? So it wasn't prepared for litigation. So you can't argue that it's got legal professional privilege. And if it's an expert report, that privilege, the rules take that away anyway. So there's no privilege aspect to it. Basically, it would have to be disclosed because it meets all the rest of the criteria.
Is it relevant to the pleadings though?
Well, it's refuting the Patricia's assertions with respect to the overruns and cost and delay. So it tends to suggest it might be. We can't say definitively because we don't have all of the pleadings to look at. But on the face of it, I'd say it probably is relevant because that's the issue. Is the cost overruns and delay, and that's associated with this water table problem. So if that is an expert report about that, I would have thought that's really what the case is all about. So I think that the answer would be yes, that should be disclosed. So that's the little exercise. Have a go at it actually as a video because it works quite well. So I think that that's basically it. All right. What do we got? We've got another problem, 19. So, okay. So this one's about interrogatories. Now remember, interrogatories are basically a set of questions. Now it used to be the case you could ask as many questions as you liked. So we had cases that would have 500 questions, and basically it got to the point where it was just too expensive. So the Uniform Civil Procedure Rules reduced the number of questions that could be asked to 30. It is possible to ask more if you get permission, but generally 30 should be sufficient, or up to 30 for that matter. So we're told that Mildred delivers an extensive set of interrogatories to George in relation to this Supreme Court action. George, after recovering from the initial shock of the size of the document listing the interrogatories, considers that it's oppressive, engages in fishing for information, some of the questions seek answers related to privileged issues, and that some of them are completely irrelevant, not related to the pleadings. So you're asked to advise George on the appropriate procedure to object to a set of interrogatories, how you go about pursuing that objection before the court, and then discuss the principles that a judge should consider when considering whether interrogatories fall within all of these categories. Now, these categories here, excessive, irrelevant, fishing, oppressive, some of those are historical categories. that existed way beyond, way before the Uniform Civil Procedure Rules. So the reason I've included those is because you will see that language in older cases. The Uniform Civil Procedure Rules are a little bit narrower, but you can still fit these things within the rules. So that's the logic behind it. So probably we can, if we go through these rules, so make sure you understand them. So disclosure was about producing documents, okay? Interrogatories are about asking questions and getting answers. So one's documentary evidence, and this is really a form of oral evidence captured in a document, because you're asking questions and you're getting a reply. All right, so they're under oath as well, so that if you lie under them, you can commit perjury. So you should always ensure that you tell your client in answering these things that they have to be truthful. All right, so the entitlement is under Rule 228. I'll make it a bit bigger so you can actually see it a bit better. So it says there, a party may deliver an interrogatory only under this part. Well, that doesn't really tell you that much, does it? You can do it, but it's only under this part. Well, wonderful. So if we look at Rule 229, it talks about the delivery of interrogatories. Now, courts are pretty strict about interrogatories because they're given with leave. It says, with the court's leave. So that means you've actually got to make an application and get leave of the court to do it. A person may, so it doesn't say a plaintiff or a defendant, it is a person to be either side, may, don't have to, but they may at any time, right? Any time. So it doesn't say, you know, you have to do it up, you can do this before trial, at any time, deliver interrogatories. So who do they deliver them to? A party to a proceeding, including a third party. Now, remember the old third parties we talked about earlier? So you can give them to them as well. So, or to help decide whether a person is an appropriate party to the proceeding or would be an appropriate party to a proposed proceeding. So you don't even have to have started the proceeding. So this is where at any time becomes really relevant. You can do it quite early. To help you decide who you're supposed to be suing. Here's the bit about limiting it. The number of interrogatories may be more than 30 only if the court directs a greater number may be delivered. So you can have up to 30 as the normal process with the court's leave, but the court can direct a greater number, but generally they're a bit hesitant to do that. And then this is important. For this rule, each distinct question is one interrogatory. So you can't have a question that has about 50 questions in it. Okay, it's got to be one question per interrogatory. Otherwise, it makes a mockery of this idea of 30 questions if each can have 5 sub-questions in it. Get the idea? So it's limited. All right, so that's how you deliver interrogatories. Then if you look at 230, granting of leave to deliver interrogatories. So it can be on application without notice to another person. So that's an ex parte application in the absence of the other party. So you don't have to have everybody in court. You can just go to the chamber judge and seek an application to get leave to deliver interrogatories. And only if the court is satisfied there is not likely to be available to the applicant at the trial another reasonably simple and inexpensive way of proving the matter sought to be elicited by the interrogatory. So you're not going to get leave if the court thinks there's another way you can get that information at trial. So for example, another way you could get that information at trial is if you call somebody as a witness and ask them. That's a way of getting that information at trial. Or there might be some other way of inexpensively proving that particular matter. So you don't actually need to ask the question. And the reason why they've done this, especially this inexpensive way, is that going through this process of interrogatories is expensive because it's already cost you at least $5,000 in bringing this application. And then the other side has then got to go about the process of answering all these questions and incur costs in getting their solicitors to vet it all. And if there's, objections to it, there's all sorts of costs involved in that. Perhaps another application to object to the interrogatories, that'll have to be heard, another 5,000. So you see how the costs can really balloon out? So that's why they're trying to constrain these things. Okay, and then it says the application must be accompanied by a draft of the interrogatories. So you've got to give the judge a copy of the questions, unless the court otherwise directs. Well, it's highly unlikely that they're going to say, well, we don't need to see them. They want to know what the questions are. And then it says, however, a magistrate's court may not give leave for this division unless the amount sued is more than 7,500. So what that's about is it's recognising that this process is expensive, so that it's reminding the magistrate that it may not be a good idea to actually have all of these interrogatories because of the cost, especially if it's a really small matter. Okay. Then you come down to answering the interrogatories. A person to whom interrogatories are delivered is required to answer them. So you can't just say, I'm not answering these things. You're required to answer them. And you've got to do it within the time the court orders. And you do it by delivering the interrogating party, the person who's asking you the questions, the answers and an affidavit verifying the statement. In other words, it's on oath. The answers basically are on oath. You're verifying that they're true. Okay. All right. Keep going. Statement and answer to interrogatories must mandatory, right? The language is must, not may. Must answer the substance of each interrogatory. So you can't give a sort of an answer that isn't an answer. It's not the politician's answer. You've actually got to answer the question. Okay. Answer the substance of each interrogatory, or if you don't want to answer it, you've got to object to it. The answer must be given directly without evasion or resort to technicality. So you can't play games around answering these questions. Although people will, but the rules say that you shouldn't. If you're objecting, you have to specify the grounds of the objection and the facts upon which the objection is made. So an example of an objection would be, I object to this on the basis that this is a privileged document. Okay. And all of the grounds for the objection are in Rule 233, but that's a good example of one. There it is there, privilege. See down there, 233E, privilege. Another one is that it's vexatious or oppressive. So it might be vexatious, you're suing Colonel Sanders because they happen to poison you from a fried chicken. You're asking, what is Colonel Sanders' recipe? So that may be vexatious. It's not relevant necessarily to the claim at hand. Or it might be oppressive. I want you to tell me what's written on the voice box recorder of the plane that's sitting on the bottom of the, the Maranoa Trench in the Pacific. It's oppressive because how on earth are you going to actually obtain that? And that's also relevant to this one here. About the expense. Well, oppressiveness can be related to expense. It can relate to time involved in doing it. You might be asking something. Well, we want this particular. What did this particular document say? And that particular document, for example, is buried in 500,000 other documents, and there's no index. You can't find them, which would mean you would have to read everything to try and locate that particular document. That might be oppressive. Then there's this in here, you can see there is likely to be available at trial a reasonably simple, inexpensive way of proving the matter sought to be elicited by the interrogatory. That's the same thing that was mentioned earlier. So it might be able to be answered by, for example, a witness rather than being answered by this interrogatory. might say that it's not reasonably necessary to enable a court to decide the matters in question between the parties. So in other words, it's not really relevant to the pleadings, and it's not necessary, not reasonable. It says reasonably necessary for the court to actually decide the question. It's not that important. And that's fairly similar to the first one. It does not relate to a matter in question or likely to be a question between the parties. So the first one, it's just totally unrelated to the pleadings. B is really saying it's not really that important in answering that particular question in the pleadings. So they're the grounds you can argue. And then the court obviously is going to consider all those things. They may, you can see there, actually require more detail. So if the court's not happy with the grounds of the objection as stated, it can ask for more details. And if the court decides that the objection is sufficient, in other words, it's valid, yes, it's sufficient and valid, then they don't have to answer it. All right, so there's the logic. Then you've got unnecessary interrogatories. So this is a bit like this one up here, not reasonably necessary, but it's repeated again in 234. The court may on application order that a person is not required to answer an interrogatory, or order limit the extent to which a person is required to answer an interrogatory. So you can have arguments over the extent to which you answer things. And then finally, after all of that, there's the consequences of not answering an interrogatory. So if you don't answer it, or you don't give a sufficient answer, in other words, you're being evasive, the court can order a further answer, order an answer if you didn't give one, or a further answer if you only gave sort of a half-baked answer. It can order you to be orally examined, in other words, hauled into court and interrogated. Or see if the person is not qualified to make the affidavit verifying the statement in answer to the interrogatories. In other words, you've asked somebody that doesn't have the knowledge to be able to answer the question, then the court can order a qualified person or individual to attend to be orally examined. In other words, you get in here the person who has the ability to answer that question. And then there's all sorts of powers under Rule 237, which is another rule, but I didn't post that up there. So you get the idea, and you can see here how this can really degenerate into a bun fight and cost a lot of money. So that's why they're trying to limit the amount of these sorts of questions.
Stephen, I think it would also be very tricky answering some questions that really might assume something that's still to be tested or proved at trial.
Absolutely.
So you would be able to, you could object on those grounds.
Yes.
Yeah, okay.
Absolutely. Because remember, this is way, way, way before the trial. So you have the benefit, you've probably gone through disclosure. So you'll have the documentary side of it, or it'll be happening at the same time. But usually you would wait until you've got the documents, and then you go through all of that and you're thinking, okay, I understand what the documentary evidence is saying. Then you think about, all right, well, what other sorts of questions would I ask? And then you would look at this. Now, not every case has interrogatories, because, this is really expensive stuff. As you can see, the arguments and the costs, this could go on, all sorts of skirmishes and battles about all of this sort of stuff. So, yeah, it's a real tactical game with all of this sort of stuff. All right, so that's explaining the process. So I think we've got that. Now, let's have a look at this question here. Excessive. So that terminology. Now, we didn't see, I don't think, the word excessive used in the UCPR rules. If we go back up here, if we did a search through this, I don't think there was any reference to the word excessive. Yet you'll see that in older cases. Okay, so I think the way to deal with that is to say, well, we don't really have the word excessive, but vexatious or oppressive is there, and that's about as close as you get into this concept of excessive. So excessive is generally about the volume of questions. And you can see really excessive was related to an historical situation where you could ask hundreds of questions. But now it's been limited down to 30. That notion of excessive is really been lost its importance, but it still could be vexatious or oppressive. And that's probably as close as you get to that term. So if you see the term used in older cases, you know that we've got a difference now in the rules. It's all about time and effort in answering the questions. All right, then you've got irrelevant. Okay, so if you look in rule 233, it says does not relate to a matter in question or likely to be in question. That's really the test of whether the item's relevant or not, or if it's irrelevant. So you don't see the word used that it's irrelevant, but that's what it relates to, that bit in green in 233. Okay. All right, there's some little discussion there of some cases, but that's the basic idea of how relevance fits in. Then you've got invoking privilege. Now, privilege was mentioned, wasn't it? Because that's a ground here under 233 for objecting to answering an interrogatory. So if we have a look at invoking the privilege, you've got legal professional privilege. Now, that's something that you would have come across in a few times probably. You would have come across that in probably legal professional conduct, that unit if you've done it. And there used to be the sole purpose test, and then there's the dominant purpose test, which is really dominant now.
We did it in evidence as well.
Oh, evidence, of course. Yeah, you do it in evidence as well. So it does crop up in a few subjects because it's really important. That's one of the big benefits of being a solicitor. That's one of the things that helps you stay in business, if you can protect things and don't have to disclose them. So that's one ground. Self-incrimination. So that's all about, as it says there, penalties and forfeitures. So, you know, if you're subject to a criminal penalty, you know, you risk being put in jail, or a civil penalty or a fine. The other one is forfeiture, where something can be forfeited from you to the Crown. So self-incrimination is there to protect you from having to answer a question which exposes you to that risk. Then you've got public interest exclusion or privilege, which is Crown privilege. Does anybody remember what Crown privilege relates to? Usually you see it with cabinet documents and things like that. So it's protecting the Crown's position. Then you've got
national security.
Oh yeah, national security documents, all those sorts of things, ministerial documents, cabinet documents, all those sorts of things. Then you've got the last one, exclusion of settlement negotiations without prejudice communications. Okay, so we talked about that earlier. Now, there are some other privileges that exist in other jurisdictions in Australia that don't exist in Queensland. You know, I think some of them might still retain marital privilege. There's another one relates to protections for reporters, you know, the press, which don't necessarily exist in Queensland, but they're certainly the ones that we're focused on here. I think the textbook from memory, it outlines some other ones in other jurisdictions. So depending on where you're going to be arguing this case, you need to check what the privileges are in that jurisdiction, because they do differ.
Just on those privileges in other jurisdictions, you'd have to be across that, because if you had a case that was that had the other side in the other jurisdiction, even though it's in Queensland, which rules apply? Is it the Queensland privilege rules or the rules of the other jurisdiction?
Well, this comes down to all of those rules that we saw with you know, some of those cross-vesting type and jurisdictional type things. My initial answer to that, because I think it depends on the facts, but my initial answer to that is that the evidence law of Queensland would be applied. So it is a bit, yeah,
It would probably, you'd start with the assumption that's the evidence law of the jurisdiction in which the trial.
Yeah, the state in which
held,
the proceeding it started. That's just your starting position. So I'm just thinking of the witnesses, they're brought within the jurisdiction. So, you know, they're on oath, they're in the, you know, in the witness box. Oh, the other one was priest and penitent. I remember. Yeah. So
Might be medical too, I think, isn't it?
yeah. Yeah, I won't start looking it up, but there's a few of them. But you're right. The main thing is you've got to check the position in the jurisdiction which you're suing, because they are different. There are variations. There's also variations not only between, there's also variations between, say, the federal court and the state courts. There's variations there as well. Not just between state Supreme Courts, but between the federal and state levels.
And I believe they've tried to limit recently the privilege for, say, priests and what have you in terms of position.
That's right. So, you know, these are all things that are argued in the public, and, you know, sometimes these privileges gain traction and other times they don't. So, you know, something like priest and penitent would have been a lot stronger in, you know, in the past. Even marital privilege would have been stronger in the past than it is now. So anyway, we won't get into a massive argument about privilege, because we could spend a whole course looking at privilege. But for our purposes, you need to be conscious of what privileges are available in the jurisdiction which you're suing, and that can be a ground not to disclose. But always be wary of the rules, because we saw an exception with expert reports. All right. So now, even the privilege against self-incrimination, that one, I just made a note here to show you that can be overruled or abrogated by a statute. And here's an example: the Work Health and Safety Act in Queensland. It actually removes that privilege of self-incrimination. So let's see what it says. A person is not excused from answering a question or providing information or a document under this part on the ground that the answer to the question or the information or document may tend to incriminate the person or pose the person to a penalty. So don't always assume that if it's exposing a person to a penalty, that automatically they have a privilege and they don't have to answer. You've always got to look at whether there is a relevant statute dealing with your particular facts. So that's why I put that. It's not relevant to our problem, but I put that in there because it's important for you to just don't assume that automatically, if you think there's a privilege against self-incrimination, it protects you in all cases, because it doesn't. And there's an example of one where it doesn't. So always look. Okay, all right. There's some old cases, some cases there about the different sorts of privileges. Let's see, fishing. Yeah. So fishing. So this was really an historical thing as well. The idea is that you would just ask questions to try and prove your case. So basically, you're just asking lots of questions, casting out your net, if you like, and you're hopefully going to pick up information which comes back to you and assists you in your case. That's the sort of notion of privilege, of fishing. So you can see here, Tony Morris wrote he's a QC now. He wrote an article many years ago when he was a junior. Interrogatories of fishing, if their purpose is to fish for evidence which may or may not exist, but it cannot be said that an interrogatory is fishing if it is directed to issues of fact which have been squarely raised on the pleadings and put in issue by the opposing party. So, in other words, he's saying it's not fishing if you're asking questions that are directly relevant to those pleadings. And that's what the actual rules say. See, 233, it says, even the grounds for objection does not relate to a matter in question or likely to be in question. So if it is if it does relate to a matter in question or likely to be in question, then you can't use that as a ground for objection because it's directly relevant to the pleadings. The other thing, if you read his articles, is you really often you don't ask questions that you don't already know the answer to, if I can put it that way. You're trying to get the other side to say on oath, or really they're effectively admitting something, aren't they? They're going to say on oath in their answer what you're hoping they will. I mean, sometimes you might be lucky and ask a question and then you get information right out of left field that you weren't expecting, but generally the way you frame these things is that you've got an idea of what the sort of answer you're trying to get back. That it's got to be related to the pleadings. So that's
related to the pleadings, would that include any defences as well that are brought up?
Yeah, the pleadings of the defence. I mean, the defence could admit things, for example, as part of the defence. So that would if it's something's admitted, it's no longer part of the proceedings. So that you wouldn't even be asking questions about that because it's admitted. Yeah, it's the entire pleadings. It's not just the claim and the statement of claim, it's the whole set. So if there's a claim, statement of claim, there might be a defence, there might be a reply, etc. A whole lot of the pleadings are considered together when you're looking at these questions and interrogatories. Then you got this one, oppressive. Okay, so you've got this case here, American flange case. The court has an inherent jurisdiction. Here's that term again. Remember we talked about that quite a while back, inherent jurisdiction? So that's a jurisdiction. It's not a statutory jurisdiction. It's not under the rules. It's a jurisdiction that exists by virtue of a court being a superior court of record. So it's there to prevent abuse of process. So you can argue that oppressive interrogatories are an abuse of process because it's requiring the person who's got to answer these things to do too much, basically. It's oppressive. So there is inherent jurisdiction to strike out interrogatories which are oppressive or an abuse of process. Now, you don't actually need to rely on the inherent jurisdiction anymore because it's written in the rules. Now, that's not to say that the inherent jurisdiction no longer exists, because it does exist, but generally you would rely on the rules because it's now been written down. It's like it's been codified in a way. All right, so you can see here, Richie, that's a Supreme Court practice in New South Wales. It says oppression is not a precisely defined concept, and you can't really define it. It's sort of one of those things you know it when you see it, if I put it that way. And may include concepts such as unduly burdensome obligations. See different cases here. Excessive numbers of interrogatories. Well, you're not going to have that anymore because they're pretty limited to 30. Search of old records. That can be a problem because it can be very expensive. Plus, you've got to find them, and they might be in a really bad state, and they might need, restoration to be able to retrieve the information out of them. They might be at the bottom of the harbour, bottom of the ocean. If it's voluminous, anything voluminous is, where it's a massive amount of work, basically, that can be oppressive. If it can be obtained by other means, so if instead of going through the thousands of volumes, if there is some other way of getting that information, for example, if there's somebody who was the custodian of all of that information is very familiar with it, maybe it's better to put them in the witness box and ask them, because they know the answer, rather than try to fish it out of a library. Here's another one. Interrogatories designed to discover the trade secrets of another party may be oppressive. So that's your Colonel Sanders and Coca-Cola sort of case. And this is the other one. A set of 54 interrogatories in multiple parts amounting to 586 questions on quantum in a personal injuries case was struck out on the grounds of being oppressive. So that's that. That's why they wrote in the rules that you're limited to 30 and it's got to be one question per interrogatory, not multi-question. Because you had cases like this one here where people were, 586 questions. in that particular case. So there you go. All right, we get the idea. So you read those old historical cases, you see these terms, you'll know what they mean and how they relate to the newer rules. That's really the objective of the whole question here, so that you can read the old cases with a better understanding.
I did have a question there, Stephen, in relation to, you've got your 30 questions, but do they have to all be asked at once, or can you take it in a block of 5 and then get the answers to that, which may raise another question, go back for another 5?
You could do
Because
that.
the cost would be associated with each event of
Yeah, it's
a
expensive.
group.
It's not economically viable to work that way. And the trouble is, when you got to the end of the litigation, and if you weren't successful, then you got to produce a bill of costs. And the taxing officer, when looking at that, will say, you should have asked all of those questions in one application, not 5 applications. I'm only going to allow you the costs of 1 application. So you'll get penalised at the end for the excessive costs. And that, that in itself might be a ground for objection. If you kept doing, you might get away with it on the first one. If you come back for the second one, one of the things I'd be arguing is that this whole application was, if you look at our grounds of objection, I'd be saying it's oppressive because it's making me incur all these costs. So, yeah, basically you would do it once.
So say you asked your first 30, or you had 29 legitimate questions, let's say 30 for argument, and then the answers to the 30 questions raised another legitimate question, you could still seek leave to go back.
You could. Yeah, you could, because
if it raised legitimate questions.
Yeah, because see here, it says number of arrivals may be more than 30, only if the court directs a greater number may be delivered. So you can get permission, but it's going to cost you. So you've got to balance up, the benefit as opposed to the costs.
If you legitimately thought, you genuinely thought that the answer to that question might force a settlement,
yeah, it certainly raise it with, in those sort of circumstances, you think, okay, on the balance, in terms of the cost involved and the potential benefit of getting an answer to this question, we'll go back and we'll ask it. We'll ask leave to ask that question. Yeah, but generally this is a game that you do once. It's because it's just too darn expensive. Okay. Other questions about disclosure generally or interrogatories? We're all happy with what the general ideas are and how they all sort of fit together? All right. Well, if you have any particular questions, don't hesitate to email me. But that's basically what we're looking at for this area. All right. So I'll just stop sharing that. And unless there's other questions you want to raise about anything, we can, we'll stop there. It's good to see you again. I'm glad you've all survived the assignment. I was getting a bit worried there at a point. It seems that you've come through. The answers that have been marked so far don't seem too bad. So, yeah, it was challenging. What seemed to be a pretty straightforward sort of situation. It had a lot of twists and turns in it. Anyway, all right. I'll see you next week. Okay.